So, allow me to introduce our speaker this afternoon. All right. So, our speaker this afternoon is the current head law librarian of the UP College of Law Library. He has a degree in Bachelor of Library Science and a master's degree in Library Science as well from UP Diliman, and a law degree from San Pablo Colleges, San Pablo City. He is the current vice president of the Network of Academic Law Librarians, a regional and national level officer of the Philippine Librarians Association Incorporated, and the PACUCOA accreditor of the library area. So to talk about the perks and pitfalls of copyright and fair use, let's all welcome Mr. Rene Manlangit.
Magandang hapon. Pa-share screen po. Wait. Narinig po ako?
Yes, sir. Narinig po namin kayo.
Okay.
Sige po, pwede na po kayo mag-share, sir.
Wait lang. Okay. Nakikita na po ba? Yung screen ko?
Wala pa po ngayon, sir.
Hindi pa rin ba? Bakit wala? Oh, no. Wait lang. Wala siya. Wait lang. Ba't nawawala? Nakikita po ba?
Ayan, okay na po, sir.
O naka-notes ba siya?
Hindi siya naka-presentation view, sir.
Okay. Let's wait. Saan yung naka-presentation mode? Bakit di ko siya makita? Wait lang po. Sorry. Bakit siya wala? Nakikita na po ba? Hello?
Yes, sir.
Okay. Magandang hapon. The topic assigned to me this afternoon is the perks and pitfalls of copyright and fair use. Wow, introduction pa lang, controversial na agad. Paano kaya to hindi maging controversial? Anyway, magandang hapon po sa ating lahat. The topic assigned is about copyright. Okay. The learning objectives, participants will learn about the types of resources that may be reproduced by libraries according to the existing copyright laws. Percentage of materials. Oops. Wait. Percentage of materials allowed to be duplicated under Philippine copyright laws. Ramification of copyright infringement, how libraries continue to extend service during a pandemic without violating copyrights. So, sa tall order po ang naka-assign sa akin. So, I hope my presentation will be able to help these learning objectives. The term intellectual property rights consists of copyrights and related rights, trademarks, service marks, geographic indication, industrial design, patents. So, pag sabing IP or intellectual property rights, hindi lang siya copyrights. Kasama po dapat ang trademarks, geographic indication, industrial design. Sa copyright, meron tinatawag na copyright and related rights. Ano po itong related rights? Ito po yung enjoyed by performers, producer of sounds recording, and broadcasting organization. So, kasama po sa copyright yung sa mga broadcasting organization, yung mga TV broadcast. In the Philippines, the IP code is RA 8293 as amended, and the original IP code is Presidential Decree number 49, Decree on the Protection of Intellectual Property. Besides sa 8293, meron ding IPR-related laws na we have to discuss or just in passing to have a holistic understanding about copyright. We have the Electronic Commerce Act, RA 8792, the Optical Media Act of 2003, RA 9239, Anti-Camcording, Cybercrime Prevention Act, Anti-Cable Television Cable and Tapping Act. So madami pong IP-related rights na may kinalaman sa copyright. Sa e-commerce Act is the Piracy or Unauthorized Copying, reproduction, dissemination, distribution, storage, uploading, etc., such as but not limited to the internet in a manner that infringes intellectual property rights shall be punished. So pwede kang ma-violate mo ang E-Commerce Act because of this unauthorized copying or piracy. Then there's also implementing rules and regulation to RA 8293. For this presentation, kailangan siguro aware tayo ng PhilCol, Pilipinas Copyright Licensing Society, and the PhilSCAP. Sa mga sinihan, yung Philippine Society of Composer, Authors, and Publisher. Sila po yung kailangan mong hingian ng permission for collective management organization ng mga copyright sa Pilipinas. And then meron din pong guidelines on copyright registration and deposit. So you have to register your copyrighted works to the IFOFIL or to the National Library para po pag mayroong copyright infringement, may mayroong public document na ikaw ang author of that particular copyrighted works. Scope and limitation ng aking presentation, only Philippine copyright laws as it pertains to libraries, kasi doon po sa ating learning objectives, libraries lang po, and minimal discussion on related or neighboring rights. Ito po yung mga audiovisual, hindi pa natin isasama ngayon kasi medyo madugo rin pong discussion to. Okay, since ang aking title is Perks and Pitfalls, Section 181.1, the fair use of a copyrighted work for criticism, comment, news reporting, teaching, including multiple copies for classroom use, is not an infringement of copyright. Ano po yung nakikita nyong nagpansin dito sa aking slide? Pwede nyo pong pasulat. Ano nakita nyong words? Ano nakasulat, Miss Aiza? Isang screen lang ako ngayon. Ano nakalagay? Meron ba nag-react? Multiple. Sa 92-93, nakalagay multiple copies for classroom use. Pwede pala yun, di ba? Pero, na-revise to ng RA 10372. So, nabago na siyang limited. Bakit kaya? Limited copies for classroom use na lang. Kasi nga, malilimit yung pag-maximize ng copyright owner ng economic rights niya kung multiple copies ang gagamitin. Kaya nung 2013, binago yung batas. Ginawang limited copies for classroom use. Kaya lang, pa nag-check ka sa official gazette, dyan sa baba, yan din yung link, pag tinignan mo yung 8293, nakalagay pa rin sa 185.1 yung multiple copies. So pwede tayong sabihin ng faculty o ng user, sir, nakalagay sa batas, multiple copies, bakit bawal? Kaya dapat alam mo, yung latest is RA 10372 na nililimit na to. Hindi na siya multiple copies for classroom use. Kaya po, ito ang summary. Kung gusto mong yung makita yung mga amendments ng 8293, better use the IFOFIL website. Kasi nilagay po nila doon sa kanilang website yung mga amended section ng 8293 para hindi ka na malito kung latest ba itong copy o hindi. Kaya mas magandang mag-refer kayo sa IFOFIL website tungkol sa 8293 as amended. Kasi yung 8293 as is, nakalagay doon multiple copies pa rin for classroom use. Another one, ito po yung isang pitfalls ng pagbabasa ng copyright laws, reproduction of published work, section 187, 1.1. Notwithstanding the provision of XXX, the private reproduction of published work in a single copy where the reproduction is made by a natural person exclusively for research and private study shall be permitted without the authorization of the owner of a copyrighted work. Clear ba yon? Sa section 187.1, pinapayagan ang natural person for private study, na private reproduction of published work. Ito po yung pitfalls na pag binasa mo rin yung section 1, dapat babasahin mo yung kasunod na section. 187.2, the permission granted under subsection 187.1 shall not extend to the reproduction of, letter B, an entire book or substantial part. So, bawal i-reproduce ang buong book ng isang private individual or natural person or a substantial part. Ano yung substantial part? As of now, wala pang operational definition. Kung one chapter, 10%, walang nakalagay sa batas. Na wala ano itong substantial part na pinapayagan lang na pwedeng kopyahin or reproduce. Kasi any work, letter E, any work in case where reproduction would unreasonably conflict with the normal exploitation of the work or would otherwise unreasonably prejudice the legitimate interest of the author, kaya hindi siya po pinapayagan. Kaya po naging limited na lang yung multiple classroom use dati. Kasi it will infringe on the unreasonable exploitation of the author of this copyright, economic copyright ng author. Kaya po, sa Section 230 ng Republic Act 8293 or as amended ng RO 372, schools and universities shall adopt intellectual property policies that would govern the use and creation of IP and adopting locally established industry practice fair use guidelines. So po, were mandated by Section 230 of the IP Code na mag-adopt tayo ng intellectual property policies para po ma-define natin ano ba yung pwedeng i-reproduce sa ating mga libraries, sa ating mga institution. Para po, pag-usap tayo sa collective licensing institution o yung PhilSCAP, kung registered po doon ang copyright owner, pwede na sabihin na in our institution, 10% of the work can be reproduced for educational purposes. So yun po ang pwedeng basis kasi meron kayong locally established industry practice fair use guidelines in your institution. As of now, wala pa po to. Kaya po yung IFOFIL, nakipag-contact sa mga librarians para ma-develop. Para as of now, wala pa rin pong nangyayari. Wala pa rin pong nagkakaroon ng updates, ano na po yung gagawing consultation para ma-define yung locally established industry practice na sinasabi. Then sa Section 171.5 ng ating IP Code o copyright, dinidefine po ang public lending is the transfer of possession of the original or a copy of a work for a limited period for non-profit purposes by institution, the services which are available to the public such as public library or archives. Take note public library, hindi lang library. So, may kailangan itong i-clearly define kasi sa batas, public library lang ang pwedeng mag-public lending. Paano yung academic library? Paano yung mga private library? Kasi dinefine as public library lang. So yun ang kailangan i-clarify sa guidelines dapat gawin ng IFOFIL. So, what is copyright? Kasi meron tayong mga nabanggit kanina, what is copyright or author's right? It's the legal term used to describe the rights that creators have over their literary and artistic work. Ang international copyright symbol, yung letter Z na sa kabilog, does not have to be affixed to the work for it to be copyright protected. So hindi po kailangan na may copyright. So bakit hindi kailangan? Bakit kailangan mag-register sa IFOFIL o sa National Library? Kasi po, ang registration will prove your ownership in case of may copyright violation, may copyright infringement. Meron kang public document to show na merong copy ang National Library or IFOFIL na yung work na yon ikaw ang gumawa kasi nag-file, ni-register mo. So madaling mag-enforce ng iyong economic rights. Pero kung wala ka nun, medyo mahirap. Ikaw nga yung sabi ikaw ang copyright owner, pero wala kang public document to show. Wala kang registration sa National Library or IFOFIL na ikaw nga ang gumawa. Kaya yun ang purpose ng registration. What are copyrighted works? Section 172, literary and artistic works are protected from the moment of their creation. So, example po ito, books, pamphlets, articles. So, mahaba po ito. So, medyo kapos sa oras. I just encourage you to check the law, RA 8293, para po makita niyo yung enumeration ng mga copyrighted protected works under literary and artistic works. Then, kasama rin po sa Section 170 yung derivative works. Ano po ito mga derivative works? Dramatization, translation, adaptation, abridgment, arrangement. Ito po yung mga derivative works ng isang original work. So, kasama rin po siya sa protected ng copyright. Then, what are the rights accorded to the author of a work? Section 127, economic rights, and Section 193, moral rights. Moral rights that govern the author connection to his work or yung attribution na dapat siyang i-cite. While the economic rights to earn from his work and give control over the use of it. So yun ang purpose ng economic right and moral rights ng copyright. Ano po yung economic rights? Ito po may 7, reproduction of the work or substantial portion, derivatives, and right to first distribution, rental rights, rights of public display, rights of public performance, and rights of communication to the public. So merong 7 ang economic rights ang copyright holder. While sa moral rights, right of attribution or to be properly cited, rights of alteration of his work, so pwede niyang baguhin, meron siyang moral rights of integrity, to object to any distortion, mutilation, modification, or derogatory action, and right to restrain use of his name against false attribution. For example, itong work na to, sinasabi gawa ni Aiza, pero sa dahil hindi naman, pwede niyang i-restrict na hindi wag gamitin yung pangalan niya kasi hindi naman siya ang gumawa nun. Right to restrain use of his name na yung work na ina-attribute sa kanya, hindi sa kanya yon. So yun ang sa mga moral rights ng author. Okay, kung merong economic and moral rights, ano naman yung works not protected in our copyright laws? Section 175, no protection shall extend under this law to any idea, procedure, system, method of operation. So hindi po pwedeng i-copyright ang idea. Ito po ang kaibahan niya sa patent. Sa patent, you protect the idea. Sa copyright, you protect the expression expressed in a literary or artistic works. So yun lang po ang kaibahan ng dalawa. And then, works of the government. 176.1, no copyright shall subsist in any work of the government of the Philippines. So yung mga work po ng legislator, ng Supreme Court, ng executive, hindi po siya copyrightable. However, prior approval of the government agency shall be necessary for exploitation of such work for profit. So kung kailangan nilang i-publish ng tulad ng ISCRA, so kailangan nila magpaalam sa Supreme Court kasi kinompile nila yung mga cases, decided case decision of the Supreme Court into ISCRA o Supreme Court annotated reports. So yun ang kailangan magpaalam yung publisher. Pero generally, ang content nun ay walang copyright, and then to the latest pronouncement ng Supreme Court, pwedeng gamitin ang mga decision of the Supreme Court for educational purposes na hindi na kailangan magpaalam pa sa Supreme Court. Another limitation, making of quotation from a published work if they are compatible with fair use. Then, reproduction of communication to public or by mass media of articles on current political, social, economic, etc. And also limitations sa copy the use made of a work or under the direction or control of the government, national library, educational, scientific, or professional institution where such use is in the public interest and compatible with fair use. As of now, wala pa itong operational definition. Ano yung public interest ng copyright? So pwede po itong pag-usapan pag meron na nakapag-usapan po tayo sa IFOFIL. Ano ito yung works made or work under the direction and control of the government. Ito po yung mga limitations sa copyright na economic rights ng author. And then isa po the reproduction or letter L, section L, the reproduction or distribution of published article or material in a specialized format exclusively for the use of blind, visually, and reading impaired person. So ito po yung Marrakech Treaty. Pinapayagan pong mag-reproduce ang mga materials for the blind, visually impaired, or otherwise print disabled. So pwede kang mag-reproduce na malaki ang font ng isang publication para mabasa ng mga visually impaired individuals under the Marrakech Treaty. So limitation po yun sa copyright. Kahit di mo na kailangang pagpaalam pa sa copyright owner kung yung reproduce mong materials is for the blind or visually impaired or otherwise print disabled individuals. Ano po yung four-factor test of fair use? Ito is section 185. Number 1, purpose of the use or the character of the use, including whether such use is of commercial nature or for non-profit educational purposes. Ano yung purpose mo? Educational ba? Academic, research, or commercial? Amount of the work to be used. Lahat ba? Kokopyahin mo? I-reproduce mo? Or chapter lang? Or 10% lang? Nature of the work used? Effect of the use on the value of the market for the original. So yun ang four-factor test of fair use. na sinusunod sa Pilipinas, or ang acronym ay, or mnemonics ay PAIN. A determination of fair use usually occurs during the copyright infringement lawsuit. At this point, the defendant accused of infringement may argue that infringement is excused under the fair use doctrine. And another limitation on copyright protection expires after a limited time. In our jurisdiction in the Philippines, copyright holder is during the lifetime of the author and plus 50 years after his death. So meron siya, yun ang limit, kaya limit after limited time nag-expire, so magiging public domain na yung copyrighted works. And then exception for certain legitimate uses. Example po, yung sa for the blind. So certain legitimate uses yun. And also, isa pa na legitimate is reprographic reproduction by libraries. Ito sa mga limitations sa copyright. Wherein lending of fragile or rare works for preservation, ina-allowed pong i-reproduce ng library by reason of their fragile character or rarity that can't be used or lent to the user in the original form. Example, meron kang Spanish collection, hindi mo na pwedeng ipahiram yung Spanish collection kasi brittle na siya. So pwede mong ipahiram, reproduce mo, pwede mong ipahiram yung photocopy or digital copy. Kasi allowed ang library to reproduce for lending fragile or rare works for preservation purposes. Ang papagamit nila yung surrogate copy. Pero nakalagay po sa ilalim ng aking slide, medium of the reproductive reproduction, reprographic is not defined term. As of now, reprographic reproduction is not a defined term, but reproduction is defined. So reprographic, pwedeng Xerox, pwedeng scanning ba, or storage ba in a digital format. So hindi pa siya defined as of now sa ating copyright laws in our jurisdiction. Preservation or replacement. Isa po sa mga limitation ng copyright sa library, yung preservation and replacement. Limited number of copies allowed as necessary to fulfill institution mandate. Copies of the work are not available from the publisher. So kahit gusto man ni library bumili, hindi available sa mga publisher na yung book. So pwede niyang i-reproduce. Pwede siyang humiram sa National Library o sa Supreme Court dahil sila yung mga legal deposit na na-mention sa copyright, na pwede dun kumuha ng kopya. Ang purpose of the copy is to preserve the work, to replace if necessary that has been lost, destroyed, or rendered unusable. So pwede kang mag-reproduce kung na-destroyed na yung copy mo, re-request ka sa library na merong kopya kasi nga, not available na sa publisher yung material. So yun yung sa mga limitations sa copyright. Walang mabili. Research or study. Allowed na mag-reproduce, kaya lang, yung nakalagay doon sa tool kanina, isolated articles contain a composite work, brief portion of a published work. Ano ito yung brief portion? Ito po yung sasabi sa library minsan, 10% or one chapter lang. As of now, walang operational definition ng itong brief portion of the published work. Parang naging practice lang sa mga libraries, 10% or one chapter. Kaya lang, paano may operationalize yung one chapter? Kasi pwedeng ngayon, one chapter. After 1 month, babalik user, chapter 2 naman. So yun ang realistically, yung limitation ng copyright natin ngayon as of now, kasi wala pa siyang clear guidelines paano sa i-implement o i-operationalize itong brief portion ang pwedeng i-reproduce. Dati, ang pag sinabing reproduce, Xerox lang or photocopying. But right now, ini-scan and then ina-upload na rin sa Google Drive. So yun yung mga challenges ngayon ng copyright kasi nung pandemic, nasa bahay lang ang lahat. So nagkaroon ng Google Drive, yung buong klase, hindi naman kinopya, sinira yung access sa Google Drive. So yun yung mga challenges ngayon ng copyright na kailangan ayusin at pag-usapan sa IFOFIL para ma-develop yung locally established guidelines ng fair use. Kasi po, yung rights ng copyright holder is international and guaranteed. Yung maximize yung kanyang economic and moral rights. Pero yung limitation and exception, ito po ay base sa national legislation or ating sa Congress po. Sila po ang magde-define ano yung mga limitation. So kailangan nating mag-lobby. In our case, in the library, kailangan nating i-lobby na pwede pala itong i-reproduce. Because, bukod sa nabanggit kanina na fragile na siya for research study, baka meron pang pwede na authorized valid use. na maging exempted ang library kasi we are using the material for educational purposes. Pero po sa library, tayo po yata ang may pinakamaraming materials na nabibili na materials na copyrighted works. Wala pong individual na nakakabili ng ganong kadami. Pero library, we purchase a lot of copyrighted materials and offer this for free to our public, to our user. Hindi po tayo nagpapabayad. Binibili natin yung libro, sinusubscribe natin yung mga periodicals, online databases, electronic databases, pero we provide it for free to our user. So maybe we could lobby to our legislator to have a more limitation afforded to libraries. So meron po tayong gagawin mga librarian para magkaroon, maging may sa batas yung mga limitation na pwedeng magamit for educational and purposes ng library. Yun po ay base sa gagawin ng Kongresong amendment ng ating copyright laws. Ito po yung definition ng fair use, na define fair use of a copyright work for criticism, comments. So nakalagay po siya. Yung definition ng reproduction is the making of one or more copies temporary or permanent in whole and in part in any manner or form without prejudice to the provision of Section 185 or fair use. So meron na pong nakadefine o legal deposit. Legal deposit natin po ay International Library, pag tungkol sa law or related to laws, ang mga publication sa Supreme Court. Sila lang po yung authorized na na-mention sa ating copyright laws na legal deposit institution. Okay, what's constitute copyright violation? Miss Aiza, lampas na ba ako sa oras ko? Nakalimutan ko mag-time?
Yes, hindi pa naman po lampas, sir.
Okay.
Pero mga 7 minutes pa po.
O para bilisan ka na lang. Okay, what's constitute copyright violation? Copyright infringement occur when there's a violation of the economic rights granted to the copyright owner or to the owner of a related rights. It may also consist in aiding or abetting such infringement. So, ang violation of the economic rights, ano ba yung economic rights? Normal reproduction kasi pinapa-photocopy or pinapa-xerox, violation of the reproduction rights ng author po yon. Or, sa ilalim, aiding or abetting such infringement. Dito po tayo magiging parang liable mga librarians or libraries. Kasi nga, kung alam natin na pinapa-photocopy na dito sinasabihan, we could be liable for abetting copyright violation. So, we have to have in our libraries mga notice na nagsasay na materials, most of the materials in our library is copyrighted. So you have to exercise caution na to observe fair use sa pag-reproduce ng materials. Hindi naman po tayong copyright police, but we have to post signages, notices na para aware yung user natin na we're not aiding or abetting copyright infringement. Kasi alam mo nang pinapapotocopy, di po sinasabihan or di ka pa nag-create ng library guidelines kung alin ang pwedeng ipapotocopy, anong part na ang pwedeng kopyahin. Kaya lang ngayon, ang hirap. Bakit po mahirap? Sino bang may cellphone dito? Halos lahat may cellphone at saka may camera. So pag hiniram mo yung libro, punta sa gilid, pinukuhaan mo ng picture, tapos na. Kaya nga ang problema natin ngayon mga librarian, ang kapal ng libro, wala pang 5 minutes tapos na, binalik na yung libro. Anong ginawa ni user? Pinicturean niya lang daw. Kasi nga, sa bahay nilang babasahin or nasa traffic, pwede niyang basahin sa cellphone niya. So ngayon, as of now, walang clear-cut guidelines doon kasi sila ang gumawa. Yung, pwede natin pagsabihan, pero hindi naman tayong copyright police para i-confiscate yung kinuha na ng picture. Kung minsan, hindi nasasabihin. Tapos naman, nabasa ko na po. So yun ang mga real world situation natin yung mga librarian. Kasi napadali ng technology yung pag-copy. Nung dati, sinisirox, ngayon, pinipicture na lang. Okay? Or yung in-scan mo na PDF, pwedeng i-share ni user sa kanyang classmate, sa kanyang group class through Google Drive. Pwede niyang bigyan di niya binigyan ng kopya, sinare nila yung access. Which another issue sa copyright and access. So, mas mahabang usapan po yun. Pero sa now, yun po yung mga realities na nangyayari ngayon tungkol sa copyright. Kasi sinabi niya, Ms. Aiza, controversial. Okay. Nabanggit na rin itong plagiarism ng previous speaker. So, hindi ko na siya i-discuss. Basta ang plagiarism is the deliberate and knowing deliberate and knowing presentation of another person's original ideas or creative expression as one's own. Ito po yung nasa Black Law Dictionary ng plagiarism. Na-discuss na po ito earlier. Okay, before I end this presentation, points to consider. Always presume that the work is copyrighted. Lalo po sa library, sabi ko kanina, almost all of our collection is copyrighted. Except siguro yun doon sa mga works of the government, published by the government. What is the nature of the copyright? Anong nature? Is it public domain? Existing pa ba ang copyright? Or ito ba under the Creative Commons na pwedeng kopyahin, pwedeng i-distribute? What is the nature of the copyright of the publication? Is use allowed under fair use? Pinapayagan ba ang fair use na pwedeng i-kopyahin ang one chapter or 10% as practice in the Philippines? Although wala siyang, di siya nababanggit sa batas, natin 10%, parang practice lang ng mga librarians na pwedeng 10% lang ang pwedeng kopyahin or reproduce. Then number 4, always ask for permission from the copyright holder before using the work even when you believe that your use would be fair. So para safe, mag-ask na lang tayo ng permission sa copyright holder. So hindi ang kahirap sa Pilipinas kung hindi siya nag-registered sa National Library o sa IFOFIL, saan mo malolocate si copyright holder para doon ka magpaalam. Kaya dapat mag-register sa IFOFIL or sa National Library para alam kung saan ka mahahanap para pag nagpaalam, madali kang makontak. Ito po yung mga references na naka-site. So I'll just give a copy, a PDF copy to the organizer para po, sabi kanina, i-email sa mga participants. So thank you. Thank you very much. If you have question, Ms. Aiza?
All right. Thank you, sir. Thank you, Sir Rene, for that very informative take on the arguments for and against copyright and fair use. No? At least now we have an idea about how to practice or how to conduct our services in the library without infringing on copyright and fair use. I'm actually looking at the Q&A portion of our Slido link, but I don't think there are any questions.
Oh, wala nang tanong? Wala ba naintindihan? What? Takot?
Or it's probably the other way around, sir. Baka naman sobrang linaw po, kaya walang masyadong mga tanong.
Dapat madami.
But siguro let's open the floor for questions. Siguro mas mainam kung ibuksan niyo po yung inyong mga microphone kung may tanong kayo kay Sir Rene so we can address them directly. Meron po bang mga tanong sa ating ayan, ito, may isang tanong si Miss Merlin. Ito ay very recent na issue to. Does Sharon Cuneta, sir, nandito po ako sa chat box ngayon na binabasa ko yung questions. Does Sharon Cuneta have the economic right to the song Sana'y Wala Nang Wakas, being the artist who originally recorded it? Bakit pumalag siya when attorney Salvador Panelo sang the song in his personal capacity? Thank you very much.
Di ko napansin, di ko nakita yung pagpalag ni Sharon ng pumalag. Pero normally, sa mga ganyan mga composer ang copyright, not the artist. Unless siya yung nag-compose. So parang sa mga movies, the director is the copyright holder, not the actor. So pag mga songs, normally may copyright is the composer. Unless otherwise, inassigned or transferred niya sa singer.
All right. So it's the composer that holds the copyright.
The copyright.
Okay. All right.
Unless po, transferred niya kay Sharon. Kung binili niya, akin na lang ang copyright. Kasi po, sa copyright, sample po, tulad nung painting. Yung painting, nagpagawa ka ng painting, pwedeng ibigay sa yung work. Pero yung copyright sa pintor. Or pwede naman na yung copyright inassign mo sa UP. Pero yung works nandun pa rin sa nagpagawa. So may iba pong malalim pong usapin to. So for the time being siguro pwede nang ganun muna.
Ayun, sige. Salamat po, sir, for your insights regarding that question. Meron na tayo ngayong 3 tanong sa Slido. So I'm currently sharing my screen so you can read the questions. Let me read the first one. Where can we ask permission if the author cannot be found or his or her whereabouts are unknown?
dito po pasok po yung IFOFIL. IFOFIL po ang National Library to protect the interest of the copyright holder kung di mahagilap, kung di mahanap. Kasi kung pwedeng patay na, pwede po yung mga heirs or estate or assigned ng copyright owner. So maghahanap po nun ay IFOFIL or the National Library. Kaya importante lang po, nag-exert ka ng effort bago mo rin-reproduce. Kung hindi, pwede kang ma-violation of copyright infringement pag reproduce mo in total or in whole yung copyrighted materials.
Alright. Okay. Thank you po, Sir Rene. Let's go to the next question. How about articles po? Mag-a-apply pa din po ba yung 10% to reproduce?
No, yun po kasi po sa Pilipinas itong 10% parang sinabi nila galing to sa Australian jurisdiction o Australian copyright laws. Pero chinecheck ko pa rin saan galing ang 10% na sinusunod natin mga librarians. Pero sa article normally parang wala kasi hindi naman siya ganoon unless makapal yung multi pages yung article. Pero normally pag article siya piniprovide natin ang copyright pero ang copy. Pero ang problema nga lang dito sa articles ay ano yung purpose? Is it for educational, for academic, or research? Porque normally sa pag tayong institution, is it for academic or educational use, pinapayagan. Wala naman pong problema. Kaya lang kung nakita mong bakit na maraming nire-request, then kino-compile pala sa bibenta, then you have to inform IFOFIL kasi kino-commercialize na pala to. Pero for educational, research, or private study, normally pinapayagan po natin ibigay.
So again, your purpose determines the permission, I guess. Okay. I think Sir Arthur would like to add to that. Sir Arthur, can unmute.
Sir,
Yes po.
yung 10% po, nakuha po namin sa, at least yung sa policy po ng main live, nakuha po namin sa US copyright, sa IRR po nung kanilang copyright law.
Okay. So yun po,
So, doon po kami humugot.
Okay, importante po ay meron tayong sariling guidelines na sinusunod. Kasi po yung limitation and exception is part of the national legislation o part ng ating Congress. Sila po magde-decide dapat. Now, in our present copyright, wala pong nakalagay. Kaya po tayong mga librarians na naggawa ng guidelines. And which parang pinattern po lang natin sa US. Okay, sige. Kung meron na palang IRR sa US, parang hindi ko pa yung nabasa na IRR nila. Thank you for that information, sir. I'll check it out later.
All right, thanks, Sir Arthur. Let's go to the next question po. Sino po ang may copyright pag anonymous yung owner? Sino ang pwedeng mag-claim? Ano pong documents ang kailangan?
Okay, pag anonymous ang work, the publisher. The publisher should claim copyright kasi imposible na publish niya kung hindi niya alam kung sino ang baka yung author gusto lang anonymous. So normally ang nagre-represent to represent the right of the anonymous author is the publisher or the printer of the copyrighted works.
All right. Thank you, sir. Let's go to the next question. Sorry. Okay. If the book is still available in the market, is it fair to reproduce the book through scanning then sharing it to others?
The whole book? No. Technically, no. Kasi may violation of the copyright. Pero kailangan mo nang malaman, available in the market, is it work of the government? Kasi pwede rin bang may nabibenta namang work ng government, di ba? Yung mga publication itong sa statistics. So, para lang, baka mas mura pang bumili ka na lang kaysa mag-scan ka. So, you have to think kung, kasi parang 250 o 300 lang ata ang national statistics ng mga publications, pero pag in-scan mo, mas mahal ka pa. Pero you really have, generally, dun sa mga commercial publications, hindi po pwede.
Alright. Thank you, sir. Share lang din po namin na sa atin, ang practice natin is if it's in the public domain, Or
Yeah.
if it's out of print, that's the only time that we can reproduce the book. But if it's still available in the market, of course, you should endeavor to purchase the book. Para wala tayong
Habit.
issues
Yeah.
po sa copyright. Anyway, sige, let's go to the next question.
Biglang
Overlapping.
dumami.
Oo nga po. Dumami yung tanong. Overlapping with the prevailing IP code is PD 812 Series 1975 still in effect. So, tinatry ko po siyang
Ano
hanapin
yung
dito.
PD-182? Kasi PD-49 yung precursor ng 8293. Kaya ano po yung 812?
Ito po, sir, tinatry ko siyang i-access dun sa OG. Ayun, nakikita niyo po ba sa screen?
Yeah.
Ayun, so...
Legal deposit. Okay. Sa batas, kung meron pong nilagay na legal deposit ang ibang institution na na-assign, pwede silang tumanggap. Pero sa copyright law, ang sinasabi lang, yung copyright owner ay pwede mag-deposit ng legal deposit sa National Library and Supreme Court for Laws or legal publications. Yun lang ang sinasabi. Pero kung gusto niya magdagdag, maglagay dito sa another legal deposit, pwede naman. Kasi syempre, magbibigay ka ng kopya, di mababawasan yung kita niya. So, by law, sinasabi lang, National Library and Supreme Court or Supreme Court for Law Publication, legal publication. Pero hindi po pinagbabawalan na pwede rin siyang magbigay following this PD 812 na magbigay sa, I think UP is legal deposit, cultural deposit. So pwede ka magtanggap because meron kang mandate in 812 from the author. Para ang purpose naman kasi ng pagbigay ng deposit ay magagamit yung works mo. Kasi hindi lang naman economic rights ang gusto ng author. Gusto rin niyang makilala, gamitin yung works niya. Kaya importante rin na magbigay siya ng kopya sa mga public, dapat nga sa lahat ng public library magbigay siya para magamit ng mga user, para ma-cite siya.
Alright. Thank you, sir. Let's go to the next question. Ito naman po. How to claim copyright po if my work was used by YouTubers or vloggers for monetization?
Okay. Pag sa mga claim ng copyright, you have to administrative case sa I-fulfill. Pag mga criminal case, kung saan po located ang nag-violate. Ang problema po sa YouTube, US, kaya medyo mahirap. As of now, yun po ang kailangan i-define pa natin. Kasi ito nga pong saan po yung residence ng itong mga YouTuber na to. Kung saan sila nakatira o yung lugar ng YouTube kung saan na-publish yung copyright infringement. Kaya medyo as of now, yun po dapat ayusin ni I-fulfill. Kasi nga, hindi naman siya binibenta, pero ginagamit sa monetization through ads. Ang kasi pinagsasabi lang sa copyright is through, di ba, yung commercial use, di naman siya kumikita doon, di naman binibenta eh. Yung ads or revenue, pareho ba yon sa commercial use ng publication? Yun po, hindi pa po malinaw as of now. Wala pa po tayong clear guidelines sa I-fulfill o sa ating mga congressman and mga senador.
Alright. Let's go to the next one. Hello po, paano po mag-claim ng authorship ang RA? Pinagsusulat po kasi ng articles but not included as author. RA po siguro research assistant yung
research assistant. Depende kasi at pag mga pwedeng pumasok dito yung employed ka ba? Kapag employee ka, na ginagawa mo yung work outside your regular duties, ikaw ang may copyright doon sa ginawa mong work. Pero yung ginagawa mo is related sa work, assigned work mo, duties mo, ang copyright doon sa institution. So, unless i-assign sa'yo. So, yun ang mga, kasi pag article ka, pinapasulat ka ng article, dapat nandun dapat, di ba? So, dapat sabihin mo sa boss mo. In din ang isa sa mga limitation ng citation kasi minsan sa mga scientific publication, 50 ang authors. Ito naman ang reverse. Sa normal, ang practice sa scientific world, yung mga head ng mga institution nakalagay as authors. Kaya minsan, meron pag nag-citation analysis ka, 50 authors kasi lahat ng mga heads ng unit nakasite as part of the authors. Ito naman, hindi siya naisama. Dapat i-request na sa boss niya na isama siya as kahit sa mga doon sa pinakailalim bottom na authors para po ma-cite naman po siya.
Okay. Basahin ko lang po yung tanong dito ni Sir Dan, one of our speakers. May bayad daw po ba yung RA? Okay, so, I mean, dun sa nagtanong kung may
Ako may
sweldo ba
bayad.
yung RA or is he paid? Ay, okay, may ano, ito pala yung pangalawang tanong. Related siya. Ito, ang tanong po ay, pwede po ba maging author ang RA even if they're paid to write an article?
Depende po kung ano yung pinasulat. Ano ba yung pinasulat? Ano ba yung pinagawang literary, artistic work ba ito? Letter lang ba ito? So, depende siguro. Kasi para mangyayari, commission work to eh. You're being paid for that commission. Technically, dapat may copyright ka. Pero kung part ng agreement nyo doon sa nagpagawa, so yun kailangan i-clarify. Ano yung, kasi pag employed ka, mayroong employee-employee relationship, normally, pag hindi to related sa work mo, yung employee. Pero pag related sa work mo, in that employee relationship, dapat sa employer ang copyright. Pero itong commission work na parang binabayaran ka naman per article, ito ba yung mga sa recto? Hindi naman gagawa ng article. Kasi sa-submit. Hindi ganon.
Parang ghostwriter na po ata siya.
Ghostwriter. Technically, dapat mayroon ka pa rin dapat na copyright. So, di pwede naman kung mag-submit, i-publish mo yung mga work mo. Kasi normally, pag ghostwriter, meron ka pa namang copyright talaga eh. Kung ghostwriter ka nga, mga speeches, gano'n. So, pwede mong i-publish yung work mo, then i-publish mo. Para ikaw yung copyright ng lahat ng compilation ng ginawa mo. Pero sa individual article siguro, depende sa usapan nyo nung nagpagawa sa'yo.
Agreement yan. Agreement ng nagpagawa ng article at ng author. Okay. Sige po, let's go to the next question. Since works of the government are unprotected works, can a government official claim to have written a law that he or she is not an author, principal, or secondary of?
Kasi when you say unprotected, hindi siya pwedeng i-copyright. Hindi pwedeng when you say copyright, economic rights, pwedeng i-exploit para may kita. So, hindi naman po binebenta yung mga batas. Kaya, kung hindi ka kasama doon sa author, pag-usapan nyo sa Kongreso, sa Senate, ba't hindi ka sinamang author ng bill? Kasi meron naman silang proseso doon. Iba po yung usapan na author ka ng bill, kasi wala namang copyright nga ang government work, so dapat doon mismo yan sa internal rules ng House o ng Senate kung ikaw i-recognize na author of that particular law or bill na pinapasa nila.
Alright, may follow-up question po siya doon, sir.
Ano po yan?
Ay, sorry, yun ba yun? Ayun, continuation. And if he or she did claim, is he or she infringing copyright?
Saan po yun? Infringing? Ba't naman siya, kung siya magki-claim ng copyright? So, ito ba yung sa RA? Ito ba yung nagsiyang gumawa?
Yun kung, palagi ko ito po yung sa law, yung kung principal or secondary author. Kasi
doon naman sa paggawa ng batas, nakalagay naman yun eh. From the very beginning, kung sino yung sponsor ng bill, kung sino yung mga authors. So, doon pa lang alam mo na dapat. Doon pa lang, bago pa ipasa, bago pa maging law yung batas, dapat nagreklamo na siya. Nagsabi siya, kasama dapat ako dyan. So, parang huli na. Kung natutulog ka, wala ka, natulog ka sa pansitan. Dapat, di ba, at that moment na nag-uusapan yun sa Kongreso, bago pirmahan ng presidente, dapat, naka-recognize kang author. Nasa minutes or journal ng proceedings ng Kongreso. Isa ka sa mga author or secondary authors.
Right. Let's go to the next question. Ito naman po, sir. If a PhD student developed a product, kasama po ba ang UP sa ownership? Ano po ang extent ng ownership ng UP?
Ang product, hindi ito ba yung copyright or patent? Ano po ba yung specific? Kasi parang ang product, pwedeng patent, pwedeng copyright. Pwedeng expression, in the form of literary or artistic work, ang may copyright siyempre ang estudyante. Pero pwede niyang i-assign sa UP. Or kung patent, siya, or pwede ang UP kung ginamit niya ang facilities ng UP para ma-develop yung gano'n. So, depende po kung ano po yung product na sinasabi. O depende rin, lalo kung may grant. May grant ba yung ginagawa niyang product, nandun dapat yun, naka-specified sino may patent or may copyright sa output. Miss Amy raising her hands.
Sige po. Ma'am Ames, sige po.
Linawin ko lang, I think this is depending, tama yung sinabi ni Rene, depende ito sa what you call, product ba talaga or are you just talking about your dissertation? Dito sa ating, wait, let me look for it. Meron kasi tayo university permission page. Dun sa pinakahuling intellectual property policy ng University of the Philippines, nire-recognize ng university ang copyright ng estudyante, no? But at the same time, ng estudyante or ng what do you call this? Ng author, kung sino man ang nagsulat ng dissertation na yon or ng thesis. Pero at the same time, nire-recognize din ng batas na yun, ng IP property na hindi mo maisusulat kasi yung papel na yan kung hindi yan sinuportahan or requirement ng inyong program. Same for any product or technology that was created that is supported by the university. Meron, depende sa agreement niyo, lalong-lalo na kung ikaw ay nakatanggap ng grant mula sa universidad, no? At gumamit ka ng laboratory o anumang facilities na meron ng UP, meron silang ownership o kumbaga may say sila dun sa ginawa mo. Now, as for the extent, hindi kita masagot kasi depende yan kung ano ba ang pinag-agrihan ninyo or ano ang terms and conditions ng inyong pag-uusap. Meron tayong Technology Transfer and Business Development Office under the Office of the Vice Chancellor for Research and Development. If you want to know more about what kind of support that this office can provide for you, kasi maliban sa ganong klaseng agreement, pwede ka rin nilang suportahan. Like for example, kung gusto mong ipapatent yung iyong dissertation, meaning meron kang dinevelop na product. Halimbawa, naka-develop ka ng isang chemical na pag dinagdag mo sa tubig, bigla na lang papayat lahat ng uminom. Magandang product
Maganda yun. Maganda yun.
Oo. Kaya lang kasi yun nga, hindi mo ma-develop yung product na yun kung hindi ka gumamit ng laboratories ng UP. So para may give and take situation siya. So that would really depend on what you and the university has agreed upon. So you talk to your advisor or you talk to whoever is in your program to know more about this. Salamat tayo sa...
Dapat simula pa lang, pag-usapan nila agad. Ano yung terms and conditions.
Tsaka, basahin mo yung terms and conditions, no? Kasi, alam ko may issue na yan sa UP before na hindi naman siya, kumaga parang kiniklaim niya na siya lang ang nag-develop ng product. Pero in fact, sinuportahan siya ng UP. So, hindi niya pwedeng sabihin kasi na completely siya ang nag-develop ng product. Ayun, sabi ni Sir Dan, it's UP or college and the author. There you go. Which is expressed in the UP IP policy naman of 2011. Thank you, Sir Dan.
Right. Thank you, Sir Dan and Ma'am Ames for the insights regarding this question. Anything else po, Sir Rene, before we move on to the next one?
Yeah, next question, ma'am. I think na-explain na naman ni Miss Amy.
Alright. Let's go to the next question. If open access po ang e-books or e-journals or journals, fair po ba if we collate it in our own Google Drive and share it to library users?
I think na-discuss kayo na yung open access. So, yung open access, mayroong mga kanya-kanyang attribution. Yung pinaka-liberal, so pwede mo siyang i-share, pwede mo siyang i-download, pwede mo i-copy. So, as long ang purpose ay for educational purposes. So, kung ganun yung restriction, walang problema. Unless, yung may restriction niya, yung di ba, mayroon yung CC, BY, CC, ganun madami. So, check mo ang open access restriction. Kasi tulad nung isang materials na isang journal, meron ng article na open access pero yung buong journal hindi open access. So you check mo yung journal kung lahat ba yun pwede mong kopyahin, i-share, o yung particular na open access lang? Sa e-books, generally, pag open access, pwede mong i-share, pero check nyo pa din yung restriction dun sa nakalagay sa open access, kung green, ano nakalagay, para sure lang po. Kasi marami po yun eh.
Alright. I think na-mention din po yan ni Sir Dan kanina, no? There's no need to host it, no? Halimbawa sa Google Drive. Kasi pwede namang links lang yung ibigay nyo po doon sa inyong library users. Kasi nga open access naman. So, dapat na access nila yan online.
Siguro Ma'am Aiza, kaya siguro minsan in-house sa Google Drive kasi parang walang internet, magbabayad ng internet connection. So at least nandun lang sa mabagal lang siguro or
Opo.
sa lugar nila. Kaya minsan nilalagay din nila sa, pwede kasing kinocurate eh. So parang gusto nila nasa Google Drive. Yeah.
Ayun. Sige po, iba-iba din naman kasi tayo ng sitwasyon, no? May mga limited ang internet access, so naiintindihan naman po natin yan. Pero yun nga, nandun pa rin naman tayo sa usapan ng fair use at for academic use only. So let's go to the next question. Is copyright inherited? If the owner dies, who would own the copyright?
Yung po, ang ating pong copyright protects is lifetime of the author plus 50 years after his death. So pag namatay po siya, yung kanyang estate or yung kanyang heirs ang magmamanage ng copyright. So pwede po siyang manahin ng mga anak or sino mang immediate na sa estate ng namatay na copyright owner. Pwede niya rin i-assign yung copyright, pwede niyang hindi manahin, pwede niyang, sample, ibigay ko sa UP. O sabihin ko lahat ng works ko, pag namatay ako, wala ng copyright, pwede niyang kopyahin, pwede niyang i-reproduce. Depende yan sa gusto ng copyright owner. So tanong na, pwedeng manahin, pwedeng ipasa, yes, pwede po.
Kung ang case po, sir, is namatay na yung author pero wala pang 50 years and meron pa siyang kamag-anak. And then lumipas na yung 50 years pero meron pa rin siyang kamag-anak. Nasa public domain na po ba yun? Automatic.
Generally, nasa public domain unless merong nabago na may ginawa, na may additional works na, for example, yung anak, inedit, nagkaroon ng second edition o naging 50th edition na yon, may binago. So may iba na yung copyright ng bago. Pero yung previous pwede nang nag-public domain. Kasi pwede naman kasing yung work pwedeng i-alter or i-revise nung kamag-anak nung namatay na author.
Sige po. Thank you, sir. Let's go to the next question. Do we have a version of the Copyright Term Extension Act in the Philippines?
Ano pong copyright term? Yung pagtapos na yung copyright, parang as of now, parang wala. So, pwede natin itong isama sa pag-revise ng ating copyright law sa Philippines, sa Congress. Yung parang sinabi, hindi, copyright term extension, you mean, it is pro-author, pro-copyright owner. Pero from the library point of view, ay natin extend. Gusto natin, after 50 years, gusto na natin maging public domain. Kasi nga, sa US, ang copyright ng libro is lifetime of the author plus 70 years after the death. Sa atin, 50. Mas gusto na sa Pilipinas na dapat ilagay nila sa public domain para mas marami ang makagamit. So yun po yung purpose kasi bakit tayo mas maikli hindi naman sa ayaw natin na kumita si author, but because ang plano sa library, ang purpose natin is free access of information. Free flow of information tayo sa library. Binibili natin, pero natin pinababayaran sa ating mga user. Kaya po ina-advocate natin na mas shorter na dapat ang after the death of the author para maging public domain, para wala pa masyadong issue.
Thank you, sir. Let's go to the next question. Ay, parang nawala yung isa kong tanong. Ay, okay. Context. How Walt Disney extended the copyright of Mickey Mouse? Ito, relevant po to dun sa related po to dun sa naunang tanong. Sa copyright.
Kasi yung Mickey Mouse naman ata, it's more on the related rights. Ito yung mga videos, not necessarily the picture. So baka may alteration na ginawa, may binagong mga mukha ni Mickey Mouse. I don't know. I'm not privy doon sa issue ng Walt Disney copyright ng Mickey Mouse. Baka yun sa video. Baka ito doon sa mga, kasi baka may mga alteration na ginawa, na binago, kaya na bago. Na-extend yung copyright ng Mickey Mouse.
Okay. Let's go to the next question. Yung holder lang po pwede mag-complain sa infringement, sir? What are the ways to control yung copyright infringement if hindi naman mag-complain yung may-ari?
Yes, ang kailangan mag-complain ay yung copyright holder. Kasi pwedeng pinapayagan niya. Nanahimik siya, gusto niyang kinokopya yung libro niya kasi copyright ay copying sa form of admiration, form of parang ginagamit yung work ko nasa site ako. So depende, dapat ang mag-initiate ang copyright holder. Kung hindi siya mag-initiate, yung natutulog siya sa rights niya. Wait lang. Pakuha na sir, pakuha. Yeah.
Okay.
Meron lang pong may tanong sa labas.
Sige po, sir.
Okay, so kailangan po dapat ay mag-initiate ng complaint yung copyright holder.
Okay. So let's go to the next question. Is it possible to create a new OER, open education resource, from a portion of an existing OER that has an ND or non-disclosure license? Is the 10% rule still in effect?
Anong non-disclosure license? Ano ba yung non-disclosure na sinasabi?
Pwede po mag-follow up question just to clarify. Does ND stand for non-disclosure?
Open educational resources, meaning pwede siyang kopyahin, pwede siyang i-share. Kasi the mere fact na nakalagay sa open educational resources is given na implied na pwede siyang i-share. Ang bawal lang dyan siguro, ibenta mo. Na open education resources, tapos pinit mo, binanta mo, yun ang bawal. Pero pag i-share mo siya, I think wala nang kailangan, walang violation doon. Kahit lahat pwede mong kopyahin eh. And again, ano yung purpose mo? Dapat educational, research, private study. Pero pag commercial na, violation na yun sa open educational resources. Kasi na-defeat yung purpose. Di ba?
Okay. Sige po. Let's see, baka may follow-up mamaya for that question. But let's go to this one. Ay, sana wala. Ayun. Is it, if I wrote a book and someone from Zimbabwe copied my work, published it, and made money out of it, may habol pa po ba ako?
Meron naman, kasi part tayo ng WIPO, World Intellectual Property Office. So, meron namang international association na pwede kang mag-complain. Ang Pilipino magko-complain, then through WIPO, pwede magkaroon ng arbitration. Na malaman na ikaw nga ba, ano kaya nga importante yung meron kang registration. Ang registration sa I-fulfill or sa National Library. Na ikaw nga yung may copyright, may copy na that particular works, ikaw ang gumawa. Hindi yung taga Zimbabwe. Pero kung wala kang registration, ano yung evidence mo na ikaw nga ang gumawa? Anong proof? So yun ang importante, kailangan natin although sinasabi natin from the moment of creation, meron ka ng copyright. Kailan paano may enforce yung right mo kung wala kang kopya, public document na available na mag-check. Kaya po importante ang i-register po natin sa I-fulfill or National Library. Sila po lang po yung authorized at the moment na magtanggap ng registration. Copyright registration ng mga literary, artistic work or derivative works.
Okay. Thank you, sir. Let's go to, I think may, tungkol po dun sa acronym na ND. According to Mitch, I think it means non-derivative or no changes made.
No derivatives.
Opo.
So, kaya kung open naman siya, ang sabi dun,
Ito po, is it possible to create a new OER from a portion of an existing OER that has a non-derivative license? Is the 10% rule still in effect?
okay, iba naman po to kasi yung 10% rule, yung reproduction. Yun po parang mangyayari, parang gusto niyang magawa ng derivatives. So parang magkaibatang usapan nyo kasi nire-restrict siya doon sa license granted ng open access na restriction niya na di ka pwedeng gawa ng derivatives. Dapat yung author lang. So pwede mo siyang kopyahin pero hindi ka pwedeng gumawa ng derivatives. Magkaiba po yun.
Alright. Thank you, sir, for clarifying that.
License.
Dumami yung tanong. Sige po, okay.
Okay lang.
Let's
okay
see.
lang.
Kasi we have one more session, but let's see. I will try to answer questions until 4:30, no, para bigyan natin ng daan yung isa pa nating session. So, follow up, may assistance po ba from UP for those who want to claim copyright?
I think meron naman kasi meron naman tayong copyright office. So, copyright office ng UP. So, mag-check na lang po tayo sa UP Diliman o UP system copyright office. Miss Aima is raising hands.
Ma'am Ames? Are you raising your hand? Sige po.
I posted the link in the chat box. Yes, the UP.
Thank you, Miss
provides
Amy,
assistance.
for that.
But please consult the form.
Thank you, Ma'am Ames. So for the person who asked about assistance in claiming copyright, you can check the link that Miss Amy sent or shared the chat box. So let's go to the next question.
What
Is it
your take?
okay to download ebooks from... Ay, sorry po.
Yes, okay,
Okay lang po
tama.
ito muna. Okay.
Yes, sige
Is
pa.
it okay to download ebooks from Z Library or LiveGen and upload it to online storage and share it with library users?
Technically, no. Kasi, except kung ang nandun sa library o sa PDF drive ay orphan works or mga public domain works na. Pero kadalasan karamihan doon, mayroong subsisting pa ang copyright. Kaya depende kung ano ba yung dinownload mo. Kung yun ay subsisting pa ang copyright, violation yun ng copyright laws. Pero kung pa sa public domain na, mga works ng government, baka pwede. I-share mo sa library user. Pero generally, as kung copyrighted works na nandun sa say library o sa PDF drive, wag nyo i-share. Yun nga ang dilemma natin ngayong mga librarian kasi alam ng mga user ng say library, alam nila ang PDF drive. Baka di na nga pumunta sa library. Kasi nandun na yung PDF copy. So yun yung mga dilemma natin na kailangan magawa natin ng paraan. How to go about this. Kasi problema rin to, nung sa IFLA, nabanggit ko to na ganun nga. Nagiging problema. At hindi lang pala ito problema, nagiging minomonetize. Nakita niyo siguro sa Facebook, nasabi, research book for 99 pesos. Mag-subscribe ka, parang ganun, through GCash. So namamonetize na itong mga PDF na available sa C Library or PDF. Wag na sabihin ang website para di makita. Kasi itong C Library, may limit to, may 5, may 10, or kung may merong level, category kung anong user ka. Mada-download mo na kung guest ka lang is 5 copies per day. So may restriction din siya.
Alright, thank you, sir. Let's go to the next one. I think someone from the audience was raising their hand earlier. Pwedeng po kayo mag-unmute if you want to ask something or share your insights. Meron po ba? Nagtataas ng kamay kanina. Okay. Wala naman. Okay, sige. Let's go to the next question. Ito po. What's your take on using no copyright infringement intended? Diba parang you're committing willful copyright infringement by knowingly using someone else's content without permission?
Yes po, hindi po to excuse para di ka makasuhan ng copyright infringement. Yung sinabi mo no copyright infringement intended, hindi po sa excuse. Kaya kung yung author, copyright owner, magkaso o magkaso nga, mag-file ng complaint, hindi mo valid defense yung no copyright intended. Kaya po, kahit alam mo kasi sabi niya willful copyright infringement kasi alam mo may copyright, di ba? So hindi siya valid defense. Pag nag-complaint si copyright owner, si copyright na may holder ng copyright.
All right. I think no copyright infringement intended is as bad as CTTO. Using CTTO, no?
Yun yung mga derivatives ngayon ng pandemic, nagkaroon ng mga bagong, kaya dapat mag-adapt din yung ating copyright laws kasi maraming mga pagbabago na changes because of technology, because of the pandemic na hindi na contemplate nung ginawa yung batas. Kasi ang huli, 2013 yung 10382. 10372. So medyo matagal na. So kailangan talagang i-revise na yung ating copyright laws.
Okay. Thank you, sir. Naku, meron pa tayong top 3. Okay, tapusin na natin tong tatlong questions bago tayo pumunta dun sa last session natin for this afternoon. If I wrote a module, wrote and assessed as my graduate thesis, who owns the copyright or the intellectual property? Me or the university?
Pag sa thesis po, generally, the author o sino yung gumawa ng thesis. Unless merong specific agreement or specific or stipulation kasi university. Kasi tulad nung ginawa mong thesis, may kailangan mong gumamit ng facilities, kailangan mong gumamit ng laboratory o yung output. So meron or may grant. So depende po 'yon. Kung ina-assign, depende po sa usapan nyo ng university. Pero generally, thesis owner yung naggawa ng thesis. Except kung merong stipulation to the contrary na ina-assign mo sa university kasi nga in exchange for funding or use of the resources of the university.
All right. Let's go to the let's go to the next question. Second to the last. Can an organization where the owner of a copyright is a member of sue an artist who used the work of its member, even if such use is okay to the owner?
If kung ang work sample ay dalawa ang authors, pumayag yung isa, hindi pumayag yung isa, hindi pwede. Kailangan pareho papayag. So yun yung, or naka-assign ito sa isang license tulad ng PhilSCAP or PhilSCOL, sila yung magde-decide. Kasi normally, pumayag yung isa, hindi pumayag. Kailangan dapat pareho pumayag. Yun yung general rule.
Okay. Thank you, sir. Last question na po tayo dito. Can we make an OER material po with content from a copyrighted material provided it follows fair use?
So parang magko-curate ng materials. Depende kung yung copyrighted materials ipoprovide mo na as OER. Pwede naman siguro, depende doon sa the degree of the reproduction. Kung chapter lang, then nag-comment ka, pwede siguro. Pero kung substantive, baka violation to ng copyright. Kung ang purpose mo, then open education resources for educational but substantive copying ang ginawa mo, mukhang hindi siguro siya allowed. So kailangan nating ma-evaluate kung gaano kadami yung copyrighted materials na in-include mo para i-publish na OER.
All right. Thank you, Sir Rene. I think that's it for this session this afternoon. We were able to answer all the questions in our Slido link. Are there questions in the chat box? Let's take a look if there are questions. Mukhang wala naman pong mga bang tanong dito. Yan. So hopefully that session gave clarity to us, especially in terms of concerns regarding copyright, fair use, copyright ownership, your rights, your economic rights,
Pwede
all
i-add
other
ko lang,
rights.
Aisa.
Sige po.
Naalala
Sige
ko
po,
lang bigla. Kasi di ba tayo mas pandemic? As of now, ang kasi parang nauso ngayon yung Google Drive, sharing sa Google Drive, pero Google Drive is pwedeng makopy, kaya nasa Google Drive pwedeng kopyahin. So I think parang away naman mo lahat, may Google email. So pwede nyo i-share ang requested publication or na 10%, kung sabi natin 10% through confidential email. Kasi dun sa confidential email, hindi siya pwedeng screenshot, hindi siya pwedeng i-download, hindi siya pwedeng i-print. Pwede siyang kuhanin sa cellphone, pero isa-isahin niya yung slide. Trinay namin at using the third-party app, hirap siyang kopyahin. So mas safe from the librarian point of view na yung scan nire-request sa ROD natin, i-share through email, confidential email ng Google, ng Gmail. Para kung sabi nilagay mo 1 month lang, 2 months lang ang use, so at least after that, magre-request ulit. Meron ka uling stat. Kasi ngayon, nawawalan tayo ng stat kasi sila na nag-share eh. Wala nang nagre-request sa library.
Opo. Alright. Ang practice naman po namin ay nilalagyan namin ng expiration date. So, view only and then may expiration date. Ayan. So, again, it depends on how you will look at it, no? At kung ano yung practice nyo sa library. But these are the things that you have to consider when it comes to copyright and fair use. So, again, thank you to Sir Rene for leading this discussion for us this afternoon. If you have additional questions, maybe Sir Rene can leave his email address to answer your questions later.